Hello and welcome to a discussion that we had planned with Marit Hansen, the Data Protection Commissioner for Schleswig-Holstein in Germany. Marit, you can correct me if I pronounce that incorrectly. She's the chief of the ULD, and she's been the state data protection commissioner there since 2015. Before being appointed the data protection commissioner, she was the deputy commissioner for 7 years. So she's seen the journey of the evolution of the role of a data protection commissioner, and we'd love to learn from her about how that role has evolved, what she's learned over the years, and in the hope that if there are people who are aspiring to be data protection commissioners, or there are jurisdictions who want to learn how the data protection commissions operate, we'll give some help there. The other interesting aspect that I found about Marit's profile is that she established some privacy technology projects, and she comes with a technology background, focusing on data protection by design and data protection by default, both from the technical and the legal perspectives. Marit, welcome to this conversation with PrivacyNama. We're very, very privileged to have you here. Tell us a little bit about yourself. Tell us a little bit about your journey to becoming a data protection commissioner.
Thank you so much. I'm glad to be interviewed, and also I'm glad that something is happening all around the world with respect to basic rights, fundamental rights. And I hope very much that the digitization, which won't stop, will have a fair processing outcome, something where we really can profit as human beings, as society, and not be separated or have to suffer from undesired effects. And therefore, I think we are right on the spot on one of the most important topics today. Of course, there are others, climate change and other things that are globally affecting our world. But digitization, and obviously it's also connected with some climate change debates, also belongs to something which is very fundamental for our evolving society. So I have studied computer science beginning in 1988, and also because I was very much interested in seeing how computers and programming can affect and can ease the use of where we need to process data. So something where it makes sense. I also came from the environmental protection issues. So in my youth, I was very much similar to Fridays for Future. So something where we believe we have to change something. And I also try to see how can we combine something which is very basic and as the fundamental rights with technology. In the beginning, after my studies, where I had a thesis in the environmental issues, so some kind of expert system, how to improve environmental protection by technology. Then I looked around, and we had at that time some deficiencies. There were so few professors at university, and we had some protesting as students, and also to see how can we use technology in a better way, and what should be some like internet connectivity. Internet was very small at that time. How can this be part of enlightenment? So something where we learn from each other, where it's better to spread the information. It was long before social networks. And so this is also something where we saw already security was not very well implemented at that time. It's still lacking implementation, I think. And with data protection, to see that it's even something, well, on top or even more, that security solutions won't necessarily also solve data protection solutions. This was something we already discussed in our student groups. And one of the persons who helped with that was our data protection commissioner of Schleswig-Holstein at that time. So he was ask from our students to give a lecture and help us with understanding. And other people were from university and research, like Andreas Fitzmann from Dresden University, who was one of the first people in Germany understanding that technology is not necessarily only a risk or danger for data protection, but can also be part of the solution. So at that time, mid of the 90s, people were still anxious of technology will destroy data protection, something like that. But mid of the 90s, we had the first mottos, data protection by design or privacy enhancing technologies, in short, PETS. This was coined by John Balking. He was the deputy privacy commissioner in the Netherlands, and also Canadian. There were several people from Canada helping together with Netherlands to understand a little bit more on data minimization, on anonymization, on identities. And this was so attractive also for me that we had the possibility to start a few projects, first regional projects, but then we understood we have to be larger and discuss more, and the necessity, at least on the European level, but also discussing with everybody. And there were also other people in the US and also on your continent, helping to have good ideas and see whether this is now an additional risk, where we also have to understand how to counter those risks, how to mitigate risks, or whether this is a part of the solution. And so this is the most interesting part for me, to see that we have an environment that changes all over the time, and it's not about stopping or avoiding. It's about understanding and then mitigating the risk, and of course to try to build systems that avoid that we have undesired consequences.
So I want to take a step back first and understand, how did you end up joining the Data Protection Commission? What made you think that this is something that, because you sound like you've come from an activist background and then you became a part of actually implementing change and implementing systems, because these are almost seen as adversarial functions. How did you come to join the Data Protection Commission, and what was your initial time period there like?
Yes, in the mid-90s, so 1995, I started the work at the Data Protection Commission right after my studies. So I had the diploma in the environmental expert system area, and I was offered a few jobs in that area. And I thought, but this is less than what I did already. So it was not so interesting. On the other hand, because of these student activities, and we had a kind of strike and some constructive getting new people on board, like the Data Protection Commissioner as a professor, or also Andreas Fitzmann, I thought this is more interesting now. And so I joined this institution, the Data Protection Commissioner at that time, and it was very boring. And so I was very disappointed and thought, no, that this is not what I want to do. So I really, kind of culture shock, culture clash. Hardly any computer, difficulty in understanding encryption or so. But I was offered then, okay, do it. You get your lab. You can do something, and you can also. So my boss, the Data Protection Commissioner, he invited people to learn from. So like other professors, like people from computer science. And this was so interesting to see that we could not only profit and learn from them, but also discuss and give and take in both ways. And then I started to cooperate more with them. And I was also allowed to apply for projects then, as already an employee of the Data Protection Commission. So my former boss, he was the second Data Protection Commissioner of our state. He was willing to make it possible to have I think a colorful, a wild mixture of interesting stuff. We also did stuff on certification or on audits. For those who want to be compliant, how can they prove that they are compliant? Not only to be the guys who say, no, it's wrong, and we have to stop your processing, but the other way around. How can you guarantee that you're on the good side, that you are doing it in the right way? Or we also did projects where we had some legal support. We tried to be very service oriented, and therefore we were also called Service Center for Data Protection. But now I think this changed a lot in 2018. We still want to be very helpful, because if we try to do if we try to be very, very early in a phase of development, then of course we can prevent mistakes. On the other hand, we cannot develop the whole world. So everybody has own problems, and it's up to them to solve them. They have to understand them. We had also, at that time, we started an academy to teach people, mainly in the legal area, but also technical area, how they can be data protection officers at a public or private entity. So a full spectrum from many, many ideas. And many of them, that's interesting, are now part of the GDPR as certification, for example. Right. But in our role has changed a bit. And I think it's logic. It's logic to have a changed role as a data protection authority that is quite powerful and that should be reliable. So we are more like prosecutors now. On the other hand, we want to be helpful, but we want to teach people, and especially the public and the private service, to help themselves. So because if we have to answer each question at the beginning, we were very, nobody knew a lot about data protection. Right. There were only a few who were interested, and so it was scalable. But if we publish, for example, something, then usually we provoke that many more people want the same help. And of course, it's only fair if we help one company to help others. And therefore, we are usually not helping companies, but we encourage and try to teach how they can help themselves. And the DPOs, the data protection officers, that are the first line of defense, I would say. They can ask also back and have a direct channel to us, but they will also select what they ask, because usually it's up to them to solve that.
So a couple of things come to mind. Firstly, could you just explain how the DPA in Germany works? What is the structure, and what is the role of a state's data protection commissioner?
In the beginning, when we started, we were only responsible for the public service. And there were extra authorities for the private service, so the companies were not on the same level regulated. It was more that the state had invented or created state organizations, so we are also paid by tax money, to control itself. And sometimes it's a trust issue, but of course, if the public service, and this is administration, it's about schools, several parts in the medical area, there's also private hospitals, the police parts of criminal prosecution. If they are not controlled with respect to data protection, I know that it's a bad situation, that there might be, perhaps also because of they have a good intention, but still there will be developments that are not so good. And so there are usual checks and balances, and we are a state organization to control the state. So this was the beginning. And in Germany, we had a very fundamental decision from the federal court, or a constitutional court from 1983. It was about a census. So counting people, have statistics, and it was not as anonymous as it should have been. And therefore, the court had a ruling and invented or derived the right of informational self-determination. It's a German word. We have very long words. And the concept is to know what others know about you, and especially the citizen against the state, so that the citizen can know what the state is doing, and not the state has hidden databases or may have unfair treatment, so that it's controllable, at least that. And then people argued, but what about companies? And then was derived that also the companies have to understand and fulfill those requirements. And so this was the beginning in the 80s. In the 90s, then the idea changed a bit, or developed further to have something more on privacy enhancing technologies. And then we had another constitutional decision where it was also about technology use. It's now called the computer fundamental right. How to guarantee that the state cannot or must not manipulate technologies, and this is about if for example, for criminal prosecution, it's necessary to have bugs or Trojan horses being installed with suspects. How to control that? Because if the state could manipulate everything in your computer, then of course, what is then proof? How is evidence defined if this can be manipulated? And so there's also a fundamental right on integrity and confidentiality, especially in this area. But this is something in the public service. So we started, and this is typical then that it's a state organization, because the public service is organized because of the state law. So we have 16 states in Germany, and this means we have 16 of those data protection authorities. What about now the companies? The companies are not regulated in a state law, but in the federal law, the Federal Data Protection Act. But still, who is responsible for the supervision? It's again the state data protection commissioners. So each state has to fulfill what is now in the Federal Data Protection Act, but then for the local companies, which is, I think, quite good, because we have then short ways to visit them, and otherwise also sometimes it's a cultural thing. We in the north are sometimes different from the southern Germans, or east and west may be different. I think that's okay. But we have also a federal data protection commissioner, and he is responsible for the federal public service that is coordinated then, and for specific companies that used to be organized as public companies, for telecommunication, for postal services. Understood. So this meanwhile, there are also companies, but it's a little bit different. And now we have to coordinate, obviously. Otherwise, if everybody's talking differently, that you should do this or avoid that, and it's different in each state, that doesn't make sense. And I think there's room for improvement still, but meanwhile, everybody, and also because of digital communication, is coordinating, and I think it makes only sense. But we have the same system with courts. The court in each state can have the own ruling, and there might be differences in court rulings, court decisions.
So we have a lot to discuss, but since you started talking about structure, we'll get to decision-making challenges. We'll get to programs that you may have instituted. I want to know more about privacy by design and privacy by default, and how you feel that ought to be implemented. We mentioned something around why there shouldn't be criminal liability. So there's a lot that we'll unpack as we go along. But I wanted to understand the state level structure and how the DPA works with the state. To start off with on that, what do you, what are the structural safeguards that a DPA or that can be put in to create independence for the DPA to prevent interference from the government or the state, since you are also regulating the state? And what sort of independence, how do you ensure independence is one thing, but also alongside that, one of the other core issues is funding. And if the funding comes from the state, then that becomes a mechanism or a lever that might impact the working of an authority like yours. So how do you then also ensure financial independence?
You are right in the heart and the core of the problematic questions. That's very good. So perhaps the the data protection authorities are differently organized, as whether they are, but still they are all public service, public bodies. I think it does not matter so much which kind of internal structure the state shows. So we have a specialty, but I think it does not matter so much. But what about now? How is the independence really implemented? And I think the first thing is, who's the boss? Who's the boss? The boss is being elected from the parliamentarians. And it has to be a transparent procedure, and this is now also regulated. And in other member states, we have sometimes in Europe, we have sometimes a kind of group of a committee who is then responsible for the DPA. So they're called the members. So for us, it's usually one leading person, and the parliamentarians have then, as in the status can be different, the possibility to elect a person for 5 years, 6 years, 8 years, perhaps 12 years. So there's some range. And then also the question is, can the person be re-elected or not? And in my state, it's now 6 years as one of the periods. And the re-election can be made once. We have a similar structure here for financial control. That's also a state authority doing that financial control of only the public bodies. And there's a committee, but the boss there is elected only once, but then for 12 years. So I think there are advantages and disadvantages. And so in former times, very often the political party was in charge, chose people from the own political party, especially if they were perhaps older and had only one term to go, and then was a good job for a person. And this is now prevented, as at least as a rule, because the data protection lead, she or he has to have competence, has to know about data protection. And I think, of course, it goes without saying that this has to be the case. On the other hand, there are also other qualities that are very important. So if you only know the law or technology, and there are not so many people who know both the equivalent, you hope, of course, to have the specialists on board. So your employees, they have to be able to specialize, to be trained, to also learn on the job, learn in trainings or so. I think that it's not something where the boss can be the best worker on each case, but the understanding and also the political and the relevance of court decisions, of is it technically feasible, or is it solvable in a legal way? And if this is not understood, then I think there could be many wrong decisions. If we decide something, it's a process of we write letters or go for an investigation, and there will be findings, a protocol, and people, the company or the controller will be asked to comment on that. So there will be a hearing. And there might be that we have misunderstood everything, or that there are other things that have to be clarified. And so there's a little bit back and forth, usually in a written way. And this will be part of a file. And also this file can be accessed, not only by those who are now part of this area, but also because we have strong freedom of information rights. Right. So afterwards it can then be also accessible. And then there will be decision, for example, an order or a fine, and this can be challenged again before court. So this is now the general structure. It takes 3 months to a year to handle such a case, I think. And then if the other party, so the controller, does not accept our decision, and I think it's good that they can challenge us before a court, then it takes often 1 year, 2 years, sometimes 10 years before it's being decided. So this is a little bit of difficulty in the system.
Could you give any examples, if you're able to, on instances where you've held government bodies accountable for data protection compliance, and has there been pushback through the system in some way because they don't want to essentially make the changes? What's it been like? Because I'm just coming from an example of India where often constitutional bodies are faced with significant challenges from the government, and their independence is often under threat. We have even had instances in case of our Freedom of Information exercise, that the Right to Information Act, where in many instances Right to Information commissioners have not been appointed, or officers haven't been appointed for months at end, so that entire work comes to a halt in order to prevent information from being given. I'm just curious about what sort of conflicts can emerge, and where you face challenges, if you can give some examples.
Yes, of course. So I think also in Germany and also in Schleswig-Holstein, there's no guarantee that there's always a data protection commissioner appointed. So we had some in history. We had some cases where the data protection commissioner had to stay longer on the job, the former one. So he wasn't. The term had ended, but there was no new person appointed. There was no election. And so the parliamentarians could say, well, not this time, let's wait a little bit more. And I think this is disgraceful. And usually also the boss then is a lame duck, because people say, what are you doing here? So we have right now in Germany, the situation in, let's say, in 3 states, as of today, in 3 states, where the deputy is the only person available right now. Because in 2 states, there's no, in one state it's solved. It will be very quickly over. So this is only a small gap there. In 2 other states, it's now that the election has not happened, and it can take 1 year, 2 years or so. And I think this is disgraceful. It should not happen. Can we do something if this happens? Yes, we can write a letter to the European Commission, because there's this there's the necessity that we have an independent and therefore also elected data protection commissioner. So the deputy is not elected. He's appointed by, or she is appointed by the commissioner, but it's not on the same level. And therefore it's okay for some months perhaps, but not for, otherwise it would hinder the work. And if we write a letter to the European Commissioner, it may take years before this is solved. So this is also not a very practical thing. I think the most practical thing is tell the media and say, this must not happen. The parliamentarians, it's their task to solve this. And please dig why this is not happening. And perhaps, well, sometimes there are packages of this is the one position, this is another position. Everybody should ask for some positions and have a fair distribution. I think this is also disgraceful. If we don't think about, this is an important job and we want a good person there, and it does not attract good people for a job if the parliamentarians, well, are ignoring that. So this has not happened at that way in my area, a little bit, yes, but there was no gap. This is already quite good. What about the money then? What about, can we have a budget as we need? Well, of course not, because it's the resources are always limited. But of course you can do something with resources, and we can also measure how many complaints are there. What about the visibility and the needs? What about perhaps if there are big scandals and we have to fight some affairs, what does it mean? And in the police sector, this is quite interesting. This is an area where it's very difficult to control data protection. So the audits in the police sector are difficult because they usually are less transparent for a predefined time, because the suspect should not be informed, if not already possible. And also sometimes there are suspects who will never know that they had been suspects, because in the background checks made it necessary to dig into their history or their contacts or so, perhaps also have some measures. But then it's clear this is not a person who's a criminal, or we don't know exactly, but there's no case. So they close the case, and this person will never know that there was something in the background. And this can also happen if you take part in a demonstration and people think that some police people think that you might be dangerous, you might be a part of a database, or there are specific properties and some databases on that. And who is controlling that? And also with terroristic charges. And then the constitutional courts on the European level and on the German level said, well, we understand that police needs some data, some leeway to do their work, but a lack of transparency must not happen. So what is the easiest solution? The data protection authorities should have regular checks, so annual or biannual, or there's something with 3 or 4 annual checks, and they are mandatory. The data protection authority must not say there are no resources, sorry. It's really mandatory that those checks are being done. And if we demand that from our parliamentarians, saying, you see, the law has changed, or the constitutional courts, the rulings have changed, this is now an obligation. We must not leave out this annual obligation of investigation, then usually it works well. So it's really something where I see that then for 1 or 2 people more, this can be done. And of course, every state then is affected. Not only one state.
This is fascinating because as a part of at least a draft data protection bill in India, the move is to largely exempt government authorities and functionaries from the ambit of the data protection law. I was just wondering, just going back to a conceptual framework, do you think that there is, so I often feel that the word data protection is more about data management, and it's the kind of the framing that word data protection, the phrase data protection and data governance create, is to almost separate the concept of privacy from data protection. That it's more about governance philosophically and more about controlling data than it is actually about upholding the rights of the citizens. So I'm just curious about, what do you think are the top things that a data protection commissioner needs to think about, or what are the key aspects of the role of a data protection commission that a commissioner must be conscious of when it comes to protecting citizens' rights? And have things changed, especially after the GDPR?
So I think I start with the last one. The change of the GDPR was, in Germany at least, that people became aware of they had rights. In principle, almost each of those rights, like right to access, right to rectification, right to erasure of personal data, right to object, so withdraw your consent. This has been there for decades, but people were not aware that they had those rights, so very few. And then this was very much discussed. And also, if there's no right to access, if you want to see who is processing your data and which data are being processed by a company, and you ask for that and you get no answer within 1 month, or an incomplete answer, meanwhile you can get financial compensation if this is not happening. So it's good for a company and also for the public bodies to install some processes that they really can fulfill those rights. So before that, very few people knew about the rights, very few tried to exercise their rights, and then it was not an obligation to answer within 1 month. It was not clear that every kind of personal data were part of this right of access. And so usually also the companies did not set up any processes. More like there's a customer wanting something, manual work to look up, do we have something or not? So this was the former way of implementation. And meanwhile, people are getting more self-confident and say, yes, it's my right, and I really want to know. And very often, it does not come out of the blue. It's something where they got a letter under the wrong name, or some people claim it's a contract. It can be identity theft, but it can also be a mistake. It can be a data breach, and they want to clarify, or they don't feel taken seriously. They think you should treat me as a human being and not as some number, and at least your data processing should be all right. So these are all rights, also fundamental rights, because of transparency, because of involvement of people, that are not data management as such. The data management is having the processes that enable to answer and to fulfill those rights. And of course, people sometimes misunderstand their rights. They say, oh, you have to delete now everything. And the company says, but I have to provide, if there's a check on my financial audit, I have to provide this receipts. I cannot delete it. And sometimes this is a misunderstanding, because that's all right. The company very often has retention obligations, and not necessarily everything is then gone. So you cannot change history by saying you have to remove my file. But of course, what is happening then, it's the purpose. The purpose changes. This is also something which I, as a computer scientist, was taught differently. As a computer scientist, I learned there's data, let's use that for any purpose. And it can be so cool to have a different purpose and a new business model. And so with data protection, it's, oh, you collected those data with this quality and with this legal basis for a specific purpose and not for other purposes. And if you want to use it for another purpose, this may be possible, but think about, do you still have a legal basis for that? For example, if you asked for consent and the person, okay, you may use it for this purpose, and say, yeah, but now I changed the purpose, and oh, no, I don't want that. The consent does not cover also the additional purpose. And so this is sometimes difficult for many people in the programming society, because they think if it's there, we can use it for any purpose. And so this is also something where data management can help, because then the purpose can be part of the data set. Okay, say this can be used, but only for this purpose or only for this time frame. There can be automatic deletion and erasure, and something which is very, very helpful. But the rights can also be, is it really necessary for the purpose? Can I collect everything? Because like personalization, if you go shopping online and the company already collects everything, every keystroke, every what have you bought in the last decades, and having a recommender system. Okay, this is a business model, and we all know that. But is it really necessary? Is it necessary to being tracked? Is it necessary to get advertisement that is tailored according to your psychological profile? If I really only want to buy this book. And so this can be something where the basic service, and this is also the data protection by default, can be a very basic functionality. So you can buy the book and with the guest account, not leaving anything more. But of course, you can also give more information and profit from good kinds of recommendations. But this is a different kind of service then, so that you can choose which is now the one you want. And also, what about the risks then? If it's the psychological profile and you are perhaps manipulated. And this is also something where data protection sees this meanwhile as a risk. I think in the 70s, 80s, we could not imagine that data knowledge can manipulate in a way psychologically. But meanwhile, I think it's common sense. Perhaps we don't understand everything and cannot react appropriately. But this is a risk now we should also take into account.
Have you had situations where companies have argued against data deletion because they feel that the data has been co-created? Because essentially it's the way a user or a person uses a service that generates a particular kind of data. And what do you think about this argument of data being co-created?
Yeah, so this is also now something which is this is new. This is data portability. We have a new right that you can, and I think it's mostly, it's not so much a data protection right from the original sense, it's more against lock-in effects, that you can get a digital copy if you also contributed to this kind of data. So if it's something where, well, it's nothing where you took part, then this is difficult. And now there are, of course, some difficult question. What about some brain sensors? And by the way, I'm thinking this may create some specifics in the database. And does it really make sense if I can see this kind of data and transpose it to another service? Let's have the simple example. I have a convenient car, and the car is also collecting some information about how I'm driving and about my seat and my size and what I like or not so much. And if I change now the car, it would be very nice to take the kind of data set I created, I configured it manually, or I behaved in a way and so it was collected, and take it to the other car. And if I a rental car, for example, it's so much more convenient if this new car also knows about me, what I want the car to know.
Right.
Yeah, but so this makes sense. But of course, then what about standardization in those cars? What I know from German cars, they collect very different kinds of data and store them in a different way, and it's not compatible. So it's not so helpful right now to get this kind of
from a portability perspective.
Yes, and so, but it could be a gateway. And I think for the future, there will be ways, and then there will be standards, and it will be much easier. What we also need is not only, by the way, these taking in or out of copies of data, but also interconnectivity. So something we see with messengers, we can now use some software tools to have video conferencing, but we have to agree on the same tool or the same server. But what about phoning? We don't have to be in the same telephone networks, so because they're gateways and they help transposing that. Why not having gateways also for other services where we have more closed silos or closed platforms? Of course, it's against some business models, but I think in the fair design and also international and globalized design, we need some kind of gateways. But again, what is now about the privacy risks, data protection risks of those gateways? Are they now the mega platforms who know everything, who's communicating with whom? So you see, for each of the question, we have some solutions and some ideas where, again, there might be new challenges, and also with co-creation. And this can, by the way, happen also without personal data. We have with the situation with our farmers in Schleswig-Holstein, who want to have their area with the big machines in a way that, and so how to get the data that they really can profit the next years from this data? Or is it something where the machine lender says, no, it's mine?
Yeah, those are key competition issues which are emerging now. But I just wanted to go back to personal data, and are there have you faced any challenges in adjudicating consumer complaints, or what are some significant decisions that have been made based on user complaints? And how do you create processes for dealing with complaints that can be standardized to minimize subjectivity in a sense? How do you ensure that consumer complaints actually lead to the right outcome?
So we see that many complaints are not in a way where it's really something where the core problem. It's something where it's a small one, and so the person says, I asked 2 weeks ago for my right to access and they didn't answer. And we can answer, yeah, but they have 1 month and in answering. And so this is or they did something wrong in the cookie area. And then we have to check, and sometimes it's all right or not. And some people even tell us, but you have to set it now a very high fine. I'm so, I don't like how they treated me. So this is now something you should work on. These are mostly not the structural, the most worthwhile data protection issues. Still, they have to be
So how do you
solved.
set up processes to deal with that volume of complaints that might not be, policy creating complaints or something that changes the way data is dealt with? So how do you create processes to reduce the noise and increase the signal?
Yes, reduce the noise, I think, is a good thing here. I heard from other data protection authorities in Europe that they have a triage system that they categorize in the very beginning. And then I thought about, do we do that in the same way? Because there's no marker, no information on that. And but in principle, yes. So every person here sees already, is it something where it's a high risk, where something is right now happening? It's a data breach. They have to act immediately, otherwise the data is being disclosed all over the globe or so. Then we take immediate action, or similar with COVID now. This is now a process. This is being set up, and it will affect everybody. And so it's so important that we start, and we have to prevent this wrong data processing. Then this will be a very high priority, of course. And otherwise, of course, there's something where we have similar cases, and it sometimes makes sense to wait for similar, not so risky cases, to group them and also see then, are they really similar or not? And meanwhile, we have, for some areas, especially in the media area, some structural approach where it's so clear how to check a privacy policy, for example, of a website. Right. And is this there? Is it not? What tracker are being used or so, trackers? And then we can structure that. With police, it's usually nothing where we can standardize a lot, because there's some standard questions, like if the data is not being deleted or so. This is always a question. And very often we also take very young cases and very old cases to see how they are treated differently very often, or something where it's a high volume or not. This is about more strategies for investigation. But otherwise, we see.
Sorry. So what has been the toughest decision that you've taken as a data protection commissioner?
Say again.
What has been the most difficult decision that you've taken? Was there a decision where the complexity was such that you had to weigh multiple options? What can you give us some insight on the most challenging decision that you've had to take?
I think a challenging decision is something which is very unpopular. That you get to know you're right, but you are getting, well, a shitstorm is something that people say, but it cannot be right. You see, the world is different, and we say, yeah, but look into the law. The law is, and it makes sense that what the law is now demanding. And I think one of the most, it was not the most complex decision. It was a very clear decision, but still it's not solved for 10 years now. It's about Facebook fan pages. So 10 years ago, we ordered the Facebook fan page provider that this Facebook fan page must not be activated unless they can prove that it's data protection compliant. And but then people, and also the courts, were saying, oh, but is it really something which is not in line with data protection law? And only after the fourth instance of the legal courts, and meanwhile, of course, much more about Facebook had become common knowledge. Then it was clear, no, there are difficulties now. Let's go back and check. And only this year, so 10 years after, we will have the first decision. I hope very much that it will be the decision this year, where really data protection law is now checked, and not only whether we were allowed to order to deactivate a fan page. So this you see, the debate was on a totally different area, but this created the concept, or the better understanding of the concept of joint controllership. And this is very typical for our world. And this is then a complexity issue. Very often it's not one, as in the old times, one controller only being responsible for everything, but everybody is responsible for a little bit. And how to combine that? And the European data protection regulation has put here not the data controller, data processor relationship in place, but a joint controllership. Not necessarily that everybody, so all controllers have the same responsibility, of course not. How to divide it? What are the interfaces? And then there's a tricky effect there, because if it's about data subject rights or also about liability, they are put together. And the big Facebook and the small fan page provider or administrator, they're totally different in their power. And if the small fan page provider makes some, perhaps infringes the data protection law, so collects in addition some information, of course, Facebook does not want to be held responsible for that. But the other way is also true. And so how to do that? And this is a very old concept, which has never been put into practice until, I think, 2018. So the concept was there already, but we in Germany did not know much about joint controllership unless it's in the public sector, I think. So this was very complex, and not because it was so much to weigh, I think. But when I took over in 2015, the job as a data protection commissioner, one of the first questions was, but you will now stop this Facebook case, right? And I said, no, we will have the next steps, obviously. So otherwise, we have to be in line with what we did because it was right at that time. It's still right. And of course, the solution can be easy. Facebook can change.
Have there been moments as a data protection commissioner where you felt overwhelmed? And what can you give us an example of what that moment might have been?
I think I'm quite optimistic, and I see always who is also working and trying to join forces then. But of course, there are some effects that what are we doing here? We did so much, and now still the protection is not there. For example, Clearview artificial intelligence scraping of pictures from the networks, from all networks, and they have so many. And so right now in Germany, the law enforcement did not make use, as far as we know, of these Clearview databases, but there were several also in the European Union, so under the regimes that are harmonized here, that booked those services. And we have now something similar with the Pegasus spyware.
Yes.
And we also hear that this is obviously being used all over the places. And this is also about backdoors and Trojan horses, and so that the states are, while cultivating security vulnerabilities. And if these fundamental issues are not accepted, then I'm not sure how we can have digitization and an information society that can also technically not be manipulated. And this is then something, if we talk about that, I'm sometimes very frustrated. And it seems as if we have to follow up the discussion on encryption, and end-to-end encryption is important and must not be broken, or on backdoors, since my childhood times, I would say, because it's every 2 or 3 years repeating itself, but without a solution now, obviously.
In fact, there is a similarity between Clearview and Pegasus, in a sense that as a user, you're helpless. You have no choice in the matter. Pegasus has a zero-click install. Clearview scrapes your data without your consent. It's the same thing happens with ambient data and CCTVs, where you're constantly being recorded. And now we're seeing drones being deployed with facial recognition systems for similar purposes. It's almost as if the pace at which the privacy violating technologies are being deployed, law, policy, data protection commissions, are they in a shape to even deal with these things, with the pace at which technology is being deployed now?
Right now, I don't think so. We can have something where those who want to do it in the right way, so drones, for example, can do it in a way where they can prove that they did it correctly. And we have in Germany and also in Europe, meanwhile, registration obligations, which means that...
Right, but how can a drone get consent?
not consent, usually not. But of course, it can be geofenced. That only so if it's only about those who want to do it right, want to do it correctly, that they can prove that they are doing it correctly. And the rest then, so we get also questions. There was a drone over our house, and people are now, well, shooting drones, saying it's my self-defense. And this is some very undesired effects, but it can be also very small effects. For example, you know, the smart watches that where kids are being equipped going into school, the small kids, for 6, 7 years old, and then the parents listen in what the teachers are discussing with the children, and also they are making noise during the lessons, saying, "Oh, you must not treat my kid in that way," or so. So this is something where people have not understood that they should leave their kids alone, because it's another scenario, that it's good that the kids are on their own. It's not about preventing some dangers or so. And therefore, I think this is something where the respect for others and what technology changes also in society, that this is a little bit out of range. And I hope very much that a discussion, a debate can help that. With Pegasus and others, it's more the big scale thing. With a small drone for my neighbors, whatever, but or a satellite and resolution. And I think also if we have then at least, so I'm usually not a friend of registering everything. There have been some ideas on each database has to be in a register, and well, it's also not solvable, I think. And who can guarantee that the register is all right? But at least we should have those who are doing it correctly in some ways, and can be on satellites, because a satellite costs very much money to put into the space, and it should be something where it's clear this is a civil satellite. Of course, there will be many things unnoticed, but at least we can try to hold people or organizations responsible for what it's doing. And sometimes it's about having management processes, if it's not better, to make clear for this purpose it's all right, but for others it's not. And usually it's not something where nobody gets informed. So even with Clearview or others, there can be disgruntled employees who on Facebook you see that they are whistleblowers, that they say, what is happening here? And they have proof, or think of the Snowden files. And this means they should have a corporate responsibility and communicate it internally and externally, and otherwise, so it's a kind of self-regulation where they promise something which can be audited by external parties, including us. And I think this is a little bit a way out. But if we accept that it's a Wild West with technology, everybody can use everything and nothing is punished, this must not happen. Then we will probably have some technology-free spaces, where it's clear if you're on holiday, there's no mobile phone or no connectivity or so, that it's, but you are also not observed or surveilled.
So one of the comments that you'd made during PrivacyNama was about criminal liability. You spoke against criminal liability for companies failing to comply with data protection guidelines. How do you ensure justice without criminal liability? You know, companies can very clearly take a risk management approach to privacy, where they think that they will derive more value out of a data and fight the court cases or fight the cases without the risk of criminal liability. So how do you mitigate the potential for such calculated behavior? And you know, we've seen companies like Facebook and Google do this quite blatantly, where they've collected the data and then paid a limited amount of fine for that infringement. So how do you mitigate these situations without criminal liability?
Yeah, so I think criminal liability is a necessity for very severe and not accidental, but voluntary attacks on users or misuses. And I welcome criminal prosecution in this area, but this is not our role. So this is then, well, I can lean back and look or watch, because the criminal prosecutors are doing that. Usually they're not used to solve those cases very much, and very often they say, okay, it was not necessarily a proven criminal activity, but we can get back as a data protection commissioner with the cases, and then it's something where still it's an unlawful processing, whether it's on purpose or not. It may play a role, even if it's unlawful on purpose and not criminal law, so there's a distinction, then the fine will be higher. And of course, if we see the sort of fine sum in the GDPR can be quite high, especially so high that it's not, I think, serious. It's not possible to have an insurance for that. Probably the insurer would not like that. But if you don't know that, it seems as it's an accidental data breach. Perhaps it's still something where the first strike is only solved by a too low fine. But if this is repeatedly happening, or if we have proof or evidence that perhaps it's not a data breach, it's on purpose, then I think it will switch a lot.
Those issues will probably emerge more with data collection rather than data breaches, because companies often collect data that they shouldn't be collecting. But I was also, you mentioned intentionality, and I guess intentionality comes in only when it comes to data breaches and mistakes in those instances. But how do you also assess for intent, and especially when it comes to collection of data that they probably shouldn't be collecting?
It's very hard, of course, to prove whether it's intentional or not. Sometimes they tell that, or we have other hints, but if we cannot prove it, that's a legal system. We have to assume that it's not the case.
I mean, there was a time when I think Google was fined for collecting Wi-Fi passwords with their street mapping software, Google Street View.
Yes, and especially they lied in our hearings. There were also the parliamentarians. It seemed that they did not know that this was part of that protocol, and this is, of course, also very bad if you do it on purpose. Okay, but usually, why should they have collected passwords? I think it was not necessary for any purpose. It could have made sense if they wanted to sell it to the police or so. But this is not a business model that is very known by Google. So it makes sense that this was accidental. It makes also sense that a person who invented that wanted to grab everything possible. And you never know how. And this is also a kind of how we are educated as computer scientists. Take what you have, and perhaps later on we will find a way or so. But this means, for example, if then the company is not only asked to pay a fine or ordered to pay a fine, but also ordered to delete the full database because it's not necessary information, and to prove that the structure of the database now is different, that it's not possible anymore to collect specific data items. I think, of course, in the first run, they profited perhaps from that, but usually what did they do? Did they use the additional data? We have to find out whether this has happened, but otherwise then from that moment on, it cannot happen anymore, or if it happens, then it's very clear that it's not only an accidental data breach. So it can happen that every company collects a little bit too much, or perhaps much too much, but if it's being found out, they have to take action. And if this is not happening, and this can be a risk, they say, but we believe it's no harm, no risk, and it's also okay because it's a legitimate interest, for example. Then we have to take the time, probably because of the court procedures, and this is something where we have to argue and they have to argue, and that will be also all right, and we learn from that. It takes only so much time, and if we think of that this can happen with very small companies, but for the very big companies, it takes even longer usually, and they have very well-paid lawyers. It's very difficult for a small data protection authorities also to survive those legal proceedings. It takes months of work, and we are not used to be before court as a lawyer for everybody. And we have sometimes difficulties to find a lawyer who wants to take our side, because the other side usually can pay much more.
So I know we've run way over time, but I have two main segments to cover. If you could just speak for a little bit longer. I wanted to understand the engagement with the companies. What is the relationship between a data protection commission and the companies that they work with? Is it necessarily adversarial? Are they always at loggerheads and arguing, or are there also areas of collaboration? Are there ways in which the Data Protection Commission encourages or incentivizes implementation of policy measures, and are there companies that come in with suggestions regarding policies that perhaps need to be changed or implemented? So what's the relationship that you have with companies?
So if there's already an investigation ongoing, this is then a defined role, and there's not so much, cooperation in the sense of helping in the investigation to, let's say, to delete evidence. Of course, this won't happen, right? If then it's a strict, a clear thing. But already, very often, companies, the company's costs are also, if they have to pay a fine or if it's a naming and shaming situation, and therefore usually most at least want to seem, and in my area I have not only the impression that they want to seem, they want to be cooperative. And it's also better because they pay less. The criterion for setting up the height of the fine. They want to be or seem cooperative. And also, if something is being wrong, then usually the next question is, but how to do it right? So what do we have to change? And very many investigations, during the findings, we have the findings that say, oh, now we understood, and this can be solved easily. And because of also risk mitigation, we do already the corrective measures. And very often they don't want an order from us to say, you have to change that. We have changed it already. And of course, this is very good. Perhaps they can even avoid a fine. So this is then in the investigation setting. But very often the companies perhaps have the feeling that they are not doing it in the right way, or they want to be sure, but they don't want to strip themselves naked to say, so Data Protection Authority, come and do an investigation. It's rather, we have some question. On Twitter, they would say, I'm asking for a friend. So more kind of, let's see what is, we want a solution, and very often they have their own lawyers. And then of course, or it's an international situation where it's also clear we have something in India and in Denmark and in the UK. It's very complex. How can we figure it out? But this means they get comments and answers. And if they get answers and they say, yeah, okay, now, but now we ignore everything you said, this is usually not an option. It's not necessarily so that this is the Data Protection Commission as the only answer, of course. But we sometimes, but this is more the public service, we have the feeling we get questions, and then we give the answer, and then nothing is happening in line with the answer, but something, the third alternative or so, is popping up, and this is perhaps even worse. So I think everything boils down to if they want to be cooperative, if they want to change already, if they ask us what they should do, they get the information and they can at least reduce a fine or limit the effects. And this also, if there's a press release, this is very often happening in a case of a fine, then the press release will also mention what they did to mitigate the risk. And this is, of course, very good. We all know also in the digital world, mistakes cannot be fully prevented, but how to handling mistakes and how to regain trust of consumers. So it can even be something like they had so well organized error management that it's something more trustworthy than those who claim we have never encountered any attack. Probably because they have never encountered any attack, but not because there was no attack. So only that it's something which is helpful, and therefore we also encourage honesty, that they really say, oh, now that this has been a data breach, because if they are silent over a data breach. And I think the data breach notification is a powerful instrument. If they're silent, say, oh, this was not a mistake, and we didn't know, or so. This is later on, it's worse. And very often somebody has documented within the company that there's happened something, because they also want to be safe with their job. So if they notice something and they don't document that, it might be that the blame of the mistake or the breach has to be taken by themselves. So they will also make sure that their boss will get this information, and they will have that. And so I think this checks and balances is quite all right. And also, if there's not much communication beforehand or during an investigation, for example, in a hearing, we will also always write what is the alternative, what can be done. Sometimes it's about, like saying, video surveillance. You have to change the angle of the surveillance camera, or blocking out something. You have to blur something. So easily solvable by software technology. In some cases, it's you must not point the camera to the loo. So there's nothing in a toilet here. This won't happening. It won't be happening. And then it's mainly about deactivation or really removing the camera. But again, then it's not about you have to remove every camera, but it will be for each camera defined why this is okay or not okay, and how it can be changed.
So let's move to preventive measures now, a subject that you care deeply about in terms of privacy by default and privacy by design. What made you prioritize privacy by default and privacy by design? And can you explain some of the measures that you've taken?
Yes, so this is an old concept, also beginning in the mid of the 90s, but then taken up by Anke Bukian from Ontario, Canada, with privacy by design and specific building blocks and criteria. And we also did some work because we were part in research projects. And with research projects in an international scenario, it's very often that our German law or the European law is not applicable, or in this sector there are specific laws. And this is very difficult for developers because they cannot know each state law or regional law, and very often the law does not say how it's to be implemented. And therefore, we decided to have a simpler approach, how to express data protection goals and translate the law into technology in a better way. And from the security perspective, there's always boiling down to 3 classical IT security protection goals. It's about confidentiality, integrity, and availability. Okay, those who are doing research in this area know you can pop this up to 20 protection goals, but let's say these 3: confidentiality, integrity, availability. And then we discussed very often, because some people said, but you data protection people, you take confidentiality, perhaps a little bit integrity, and then you're fine. No. We discuss very often, in detail, and especially when we came up on ubiquitous computing scenarios with ambient assisted living, sensors. What about a house full of sensors for an old woman who is afraid of falling and has to be rescued then? And this is a not so untypical scenario. And then there was a service here in my area. They offered that you can install sensors, and the sensors will notify us as a service, and we will come to rescue you then at that time. And then we had the question how to deactivate the sensors. Oh, no. You must not deactivate ever any sensor, because otherwise we cannot rescue you. But what about now? I have visitors. What about the visitors now? Because if the visitors are there, they will rescue me. It's okay. I can deactivate the sensors. Or why do we have so many sensors in the bed? What do you want to measure in my bed? I don't agree that you measure how much weight is now in the bed, or how or one person or several persons are, whatever. We don't want that. And so we came about how to influence that in a way that it's not only transparent where the sensors are built in and what they are doing, but also how to, for example, deactivate that for a time, not necessarily for the full, because if there's the deactivated sensors cannot fulfill their purpose. But if you want this purpose to be fulfilled for specific times or not, then you have to do something now. And we call this protection goal intervenability, how to intervene, the possibility to intervene. And then, of course, it changes then the liability of this rescuing service. So this is something which is not one size fits all. You have to tailor it. So transparency and intervenability. And from the data protection discussion, we always knew about data minimization and how to separate, because of the purposes, different kinds of data sets. And this is called unlinkability. So we have now 7 protection goals: confidentiality, integrity, availability from IT security, data minimization, only what is necessary, the unlinkability, the transparency, and intervenability. And this is a set is quite stable since 15 years. And we adopted that for many research projects because the developers totally understood how to work with that. And also say, oh, but this is outside my technology area. We have to have an organizational process, or we need to express it in a contract. And so everybody could see how this is working. And if we discussed in the beginning about data access rights and data rectification and deletion, this is also something with intervenability and how do they interfere. And this is something we offered now. We put it into this discussion also for the GDPR. The words are not in the GDPR, but the concepts in principle are compliant. And therefore, we developed a standard data protection model on the basis of this, and this is also available in English, on the basis of these protection goals, and put in what are the measures now. If we want to achieve unlinkability, how does it work? And have building blocks to do that, like a firewall to separate different physical or logical separations. About purpose definitions, that it's clear the purpose is bound to the data set, perhaps also encrypted, the access controls, the automatic deletion, how to be transparent. And of course, there are always new challenges with artificial intelligence, how to achieve transparency and intervenability with that. And then again, we have to think again about what are now building blocks, can we use that or not? But this system has been quite stable. There have been many publications, and therefore we teach it also ourselves if we want to check systems, and especially if we haven't totally understood how these things will work, because it's not traditional old school stuff, but something where some new effects may be upcoming, and how to then tailor that in a fair way. So this is a full model, and obviously, I think it's better to explain it with some slides, if you can see then how everything is interlinked. But this comes from data protection research, from the international projects being imported, so to speak, to Germany, having a debate not only in Germany, but with many researchers, and especially that we found a way to communicate between the lawyers and the data protection practitioners, the DPOs, and the engineers who are developing the systems. This is so helpful.
This sounds like a lot of work, and sounds like there's a lot of effort to create processes and systems in order to execute this kind of engagement. I'm just curious about how do you prioritize your time, or how do you split your time? What are the key roles that you have in terms of, let's say, advocacy and outreach, to consumer complaints, to projects like Privacy by Design? How do you split your time in a year, or in a month, or in a week?
We have to say that we very often are triggered by external effects. That is, if the parliamentarians have now a question, and now there has been a new information on Clearview or Pegasus, this has to be prioritized because this is now where the media has to be informed, or where the parliamentarians have some ideas on new lawmaking processes or challenging governments, their own government or other governments or so. So this is something where especially I myself will always try to react on the same day. And this, but there are of course some more the conceptual things. If we have an investigation of a data center, this will take weeks for a small team. And then after some weeks, they will come to me and we will check together which are the points that are perhaps wrong, but not necessarily in our area where they are very well important, or where it's very difficult to also inform judges about the effects, how to translate that. And then we try to have the right teams. And this is also important that we always, and in former times it was more separated, meanwhile it's quite mixed, that the lawyers and the technology people, but also some people who are good in user interface design or understanding business models, that the right people come together. And also sometimes we have to express it, for example, by drawings, by making the right pictures to have the models. So usually if you read legal text, there are very, very few images. But if you want to communicate, very many people understand only if they can see it as an image, if they see a figure, or have the right numbers, of course, tables. And therefore, we also need people who gather this information and try to communicate in the right way. And we try to concentrate then on the important things because we know we will provoke questions. And this is good, this is very good, but we cannot do this for all aspects. And therefore, we also are coordinating our efforts within Germany and also within Europe, that we see that we can avoid double work and also can profit. For example, there's a good report from our Norwegian colleagues, or for Bruker Rådet, this is a Consumer Protection Council, on this deceived by design. So what about dark patterns? Yes. What about how it should not work and how to investigate that? And therefore we adopt that. It's so good. Or we also adopted things for kids, where it was a program how to teach kids and younger school kids even by some viral activist mechanisms. And it's not necessary that everybody reinvents then what we have, but that we can do that. And therefore, it's very often to try to, and also my job, to try to establish cooperations, because then afterwards, it's much easier if we can profit from each other. And therefore, I also encourage our cooperation that India and Germany and Schleswig-Holstein can learn from each other and see that how can we avoid double work, or also think about if we want interconnectivity on a technical issues, but the law is different, how to understand the differences and how to make it translatable, something like that, that it's not necessarily everybody is only fixed into on the own legal regulation, which is, of course, it's the first thing we learn. But if we want interconnectivity, cooperation, and so we have to learn from others, even if this is in the first step, not relevant for Schleswig-Holstein. But if we have a broader view, it's totally necessary that some people and those who are already good in those networking issues can do that and understand each other, because then the solution, and there are, of course, Indian processors for my area, that this makes sense then that we have the same kind of understanding.
We're almost out of time. Just one last quick question. How do you bring in competence? Do you have working groups? Do you have external advisors that you bring in? Because you've come from a technology background, but many places data protection commissioners are essentially coming in from a legal background or coming from more of an administrative background. So I would say that Schleswig-Holstein is very lucky to have a technologist as a data protection commissioner. But when you don't have certain competence, how do you bring it in?
Yeah, so it's always good to have mixed teams. So my deputy, for example, is a lawyer, and I encourage also that it's always good to have a mixture also in leading positions. There are very few European data protection authorities, for example, who have no technology person. And I personally have difficulties to understand that, but it's possible, of course, to hire then from some companies, some consultants, or some as experts if we have to, for example, do something on smart cards, chip cards. Then perhaps we don't have a person who is trained for that. Then we need external knowledge, or on connected cars. We want to have the way to understand that. But I also see that if we only have external experts, they are not, let's say, socialized in a way where they can understand the different ways of thinking. Perhaps it has improved now, because also at university, there are more courses who bridge now those skills. But still, if you want to have an academic career, you usually are very much taught and trained only on your specific topic. And if you have interdisciplinary research, what we are doing very, very often, we have also a summer school where I'm part of the steering committee. This is often counting not so much for people who want to write their PhD, but what we also do, we are teaching at university, because we have too few people applying for jobs at data protection authorities. Meanwhile, both in the technology sector, this is tradition, but also in the legal sector. And then what I said in the beginning, there might be something like a culture clash. And only that we know, be kind to each other. I think this is a big motivation.
Marit, Hansen, thank you for taking time to speak with us and help our readers and our viewers understand the role of a data protection authority. I hope for more such engagements and collaborations with you as we move forward towards setting up a DPA and hopefully even getting a data protection law before that in India. Thank you so much for your time.